Based on the cases, question A stated that discuss ATC rights, if any, in relation to Hong Kong Bank and Bersatu Bank. In my part, I will explain about the ATC rights in relation to Hong Kong Bank. Our issue will be whether Amazing Toy Company ATC has rights in relation to Hong Kong Bank, and does ATC entitled to receive payment from Hong Kong Bank as an advising bank to the ATC. Rules that are related to the cases is this issue, which is the ATC right against Hong Kong Bank, can be further explained under the Uniform Customs and Practice for Documentary Credits UCP 600 by using articles that are pertinent to this case, such as Article 5, Article 18C, Article 16, Article 16A, and Article 16C. UCP 600 explains about the principle of autonomy in the Article 5. This article explains that letter of credit is separate from underlying sales contract. The obligation of the bank to make payment is contingent on the exporter's document being in order. UCP 600 strengthens the function of bank in document restricted letter of credit transactions. Additionally, the article stated that banks only deal with the documents and not with the products, services, or performance. This means that Hong Kong Bank will only proceed with the payment to exporter, which is ATC, based on the documents. Based on this case, stated that Hong Kong Bank informed that the presentation occurred outside of the credit's validity period. This means that Hong Kong Bank will not obligated any issues between exporters ATC and importer SWTW in transactions either in the term of goods, services, or performance. Next is about strict compliance. Strict compliance elaborated in the article of 18C UCP 600. This explains that the products, services, or performance on a commercial invoice must match with what appears on the credit. This means that the ATC has no recourse against Hong Kong Bank because the presented document did not comply with the letter credits requirement. The problem with the documents appears to be that ATC's bill of lading is marked freight collect rather than freight prepaid, as mandated by the terms of letter of the credit. In addition, the beneficiary certificate of origin is signed by an employee of Hong Kong Inspections without any indication that Hong Kong Inspection is authorized by Hong Kong Custom. The document did not mention Hong Kong Inspections is an authorized agency. This is clearly not correspond with what appearing in the credit that shows ATC has no rights against Hong Kong Bank. Next, we will explain about the Article 16 of UCP 600, which is Notice of Refusal. This article stipulates that if an exporter's documents contains discrepancy, a bank is not required to honor the document and must send a notice of refusal to the exporters or its bank. Article 16A stipulates that a bank may refuse to honor a draft issued under a letter of credit if the presentation of documents is not compliant. Due to the explanation on strict compliance just now, Hong Kong Bank refused to pay ATC as the beneficiary in this case on 11 April 2023. Article 16C specifies that upon rejection of non-compliance documents, the bank must prepare a more detailed refuse notice. According to the article, if a nominated bank acting on its nomination, a confirming bank, if any, or the issuing bank decides to refuse to honor or negotiate, it must provide a single notice to the presenter. The bill of lading presented by ATC is marked as freight collect rather than freight prepaid as mandated by the term of the letter of credit. In addition, the beneficiary's certificate of origin is signed by an employee of Hong Kong Inspections without any indication that Hong Kong Inspection is authorized agency by the Hong Kong Customs. Additionally, Hong Kong Bank informed that etc. the presentation was made outside of the credit's validity period. This demonstrated that Hong Kong Bank's decision to refuse payment because the presented documents did not meet the requirement of the letter of credit is entirely correct. So, the conclusion is that based on the preceding explanation, it is evident that etc. as the beneficiary in this case has no rights against Hong Kong Bank and that Hong Kong Bank has no obligation to pay etc. This is because the presented documents did not meet the requirement of the letter of the credit. As explained previously, this is supported by the Article 5, Article 16, Article 16A, Article 16C, and Article 18C of the Uniform Customs and Practice for Documentary Credit, UCP 600.
So for my part, I will explain about etc. rights in relation to Bersatu Bank. Issue the whether Amazing Toy Company or etc. has right in relation to Bersatu Bank as issuing bank to the etc. For the rules, the Uniform Custom and Practice for Documentary Credits or UCP 600 governs the right and obligation of parties involved in documentary credits. Relevant articles include Article 14, which outline the requirement for document conformity, Article 16, which pertains to the waiver of discrepancies, and the availability of legal redress. So for the application of etc. right in relation to Bersatu Bank, firstly is the Article 14 of UCP 600 is a crucial provision that outlines the requirement for documents in a letter of credit. It emphasizes the importance of presenting documents that conform to the terms and conditions specified in the letter of credit. In the given scenario, the letter of credit issued by Bersatu Bank specifies a set of documents that etc. need to submit, including a bill of exchange, commercial invoice, clean bill of lading, certificate of origin, and packing list. Failure to provide this document or non-compliance with the stipulated requirement could give Bersatu Bank valid reason to refuse payment. It is essential to truly review the explicit terms and conditions in the letter of credit to ensure the compliance with them. So for the second one is examination of documents. As the advising and negotiating bank, Hong Kong Bank has the responsibility to examine the document presented in accordance with UCP 600, which is Article 14. Financial institutions have the right to decline payment if they determine that the document do not conform to the specified requirement in the letter of credit. The examination process involves a careful assessment of the document to ensure they meet the prescribed criteria, including the requirement quality, essential information, and coherence. If any discrepancies or inconsistencies are identified, the bank can refuse payment. It is important to consider the precise term and condition in the letter of credit and relevant legal regulation governing the document scrutiny. ETC's right and obligation in this scenario depend on the explicit provision in the letter of credit and relevant norms. Seeking legal counsel is advisable to understand the implication and available cost of action. Next, for the third one is discrepancy waiver provision. Under Article 16 of UCP 600, ATC has right to request a waiver for discrepancies in the document provided to Bersatu Bank. The bank can waive minor inconsistencies as long as they do not constitute a complete rejection of the presented document. However, the ability to waive discrepancies depends on the provision outlined in the letter, credit, and relevant legal of industry norm. In the given scenario, Bersatu Bank declined to waive the discrepancies. ATC's right concerning Bersatu Bank depend on the explicit provision in the letter, credit, and relevant legal or industry norms. Seeking legal counsel is recommended to understand the available option and potential consequences. And for the last one is the legal redress. If ATC believes it has fulfilled its obligation and complied with the terms of letter of credit, it can consider seeking legal redress against Bersatu Bank, while the UCP 600 does not explicitly provide legal remedies. ATC's available option will depend on various factors such as applicable legislation, jurisdiction, contractual provision, and dispute resolution mechanism outlined in the contract and letter of credit. Legal recourse may involve initiating legal proceeding or arbitration to enforce ATC's right and obtain payment for the delivery goods. Consulting legal professionals specializing in the international trade and dispute resolution is crucially to assess the feasibility and potential outcome of pursuing legal remedies. They can provide guidance on relevant legal status, procedural requirement, and the likelihood of achieving a favorable outcome based on the unique circumstance of the case. For the conclusion, in summary, the legal entitlement of Amazing Toy Company or ATC in relation to Bersatu Bank are dependent on the adherence to the terms and conditions outlined in the letter of credit and the submission of documents that meet the specific requirement. The non-compliance of document or failure of adhere to the prescribed criteria may lead to the bank rejection of payment. In the event of discrepancies, ATC has the possibility to request a waiver from Bersatu Bank. However, it is important to note that the bank maintains the authority to grant waiver for discrepancies within specific boundaries. The ATC may contemplate initiating legal proceedings against Bersatu Bank Bersatu Bank if it is on of the option that its responsibility have been duly discharged and that the refusal of payment was unjustified. It is recommended to engage the service of legal professional in order to assess the potential costs of action and consequences in the light of the particular circumstances surrounding the case. So, thank you.
Question B. Amazing Toy Company ATC rights against Suka Toy World STW. For the issue whether ATC will be able to recover the payment for the delivered goods through the usual channel, considering the refusal of payment by the bank due to discrepancy in documents, the liquidation of STW, and the action of its executive. For the rules, the relevant legal principle to consider are the provision of the United Nations Convention on Contract for the International Sales of Goods, CISG, and principle of insolvent law. Amazing Toy Company ATC has fulfilled its obligation by delivering the good as required. However, the situation took a turn when discrepancies were discovered in the documents presented under the examination of goods and document Article 38. As a sequence, the bank, namely Hong Kong Bank and Bersatu Bank, refused to make the payment. According to the Article 38 of the CISG, the buyer is obligated to examine the goods or notify the seller of any lack of conformity within a reasonable time after delivery. This provision emphasizes the importance of timely inspection and communication to address any discrepancy. Additionally, the principle of independence within letters of credit comes into play, where the bank's obligation to pay is generally considered separate from any disputes between the buyer and seller, subject to certain exceptions. Article 53 of the CISG establishes Suka Toy Company STW obligation to pay the price for the goods as specified in the contract and the CISG. However, the situation has become more complex due to the insolvency of STW. The principle of insolvency law will significantly impact ATC's ability to recover the payment. The outcome will depend on various factors such as available assets in the liquidation process and the relevant insolvency law that govern the case. This factor will play a crucial role in determining the likelihood of ATC recovering the full amount owed. Therefore, ATC may need to navigate the legal landscape and assess its option carefully in order to secure its rightful payment. Conclusion: Considering the circumstances of the discrepancy in the documents, the insolvency of Sukhatoi World STW, and the action of executive, it is unlikely that Amazing Toy Company ATC will be able to recover payment through the usual channel. The success of ATC claim will depend on the available asset in the liquidation process and the priority of the creditor claims. As determined by the relevant insolvency law, the principle of independence within letter of credit may be also relevant consideration in assessing the obligation of the bank.
Next is Amazing Toy Company is unable to get the bank pay. It may use any right it has against anyone else involved in the transaction. For the rules is UCP 600 control the situation. UCP 600 govern international commercial transaction utilizing letter of credit. It governs documentary credit, institutions, negotiations, and settlement. In Article 4A, the bank must verify a presentation documents. This shows in Giant Singh versus Banquet de Indochina in 1974. Next is Article 4C. The beneficiary must submit one or more original transfer documents no later than 21 calendar days after the shipment date, but no later than that, the credit expiration date. Next is Article 4B, allows a nominated bank acting on its own nomination, a confirming bank, if any, and the issuing bank 5 banking days from presentation to determine compliance, even after the expiration date or last day of presentation do not affect this period. Banker Trust versus State Bank in State Bank of India in 1991. Next is Article 61A. A nominated bank, confirming bank, or issuing bank may reject or negotiate a non-complaint presentation. This shows in C. Consar Far East versus Bank Markazi Jamhuri Islami Iran in 1993. Next, for the application, number 1 is non-conforming documents. Bill of lading reads freight collect instead of freight prepaid. Certificate of origin not signed by the Hong Kong Customs Department, so the bank must check paper for letter of credit complaints under UCP 600, and the bank withheld payments as per UCP 600 in Article 16. ATC may not be able to force bank to pay for non-conforming documents. Next, number 2 is presentation outside credit validity. The letter of credit requires presentation within 15 days of shipment and within its validity. UCP 600 Article 14 requires timely submission of paperwork. Bank won't pay for presentation delivered beyond the validity period. The credit expired on April 4, 2023 when the presentation was made. Bank may refuse the payment due to the differences. Number 3 is right against other party. ATC may seek remedy against other party engaged in the transaction. Sukhatoi World STW breaches the contract and its liquidation capacity to fulfill obligation or provide compensation may be limited. For Bank Bersatu, ATC may sue if the bank failed to advise the negotiation. Bersatu Bank declined to forgive the disparities, potentially violating the letter of credit or other laws. Hong Kong Bank advised this transaction. For the Hong Kong Bank, ATC could sue Hong Kong Bank for failing to advise. In Article 14B, requires Hong Kong Bank to respond to ATC recommend presentation within 5 banking days. The Hong Kong Association Banks in 2019 declared that April 5 until 10 lawful holiday affecting the response timeline. In conclusion, according to the information provided, it's apparent that ATC may not be able to compel the banks to pay because of the documents are insufficient and the presentation is made after the credit expired. However, if Sukhatoi STW violated the contract, ATC may still have right against other parties engaged in the sale, such as ATC. However, given that the buyer is in liquidation, the value of this right may not very high. That's all for me. Thank you.